The British Nationality Act 1981, Chapter 61, sets out the legal framework for acquiring British citizenship through various means, including birth, adoption, descent, registration, and naturalisation. The Act outlines multiple provisions related to the acquisition of nationality and the conditions under which a person may become a British citizen. Part 1. British citizenship acquisition by birth or adoption. Section 1 of the Act deals with the acquisition of citizenship through birth or adoption. A person born in the United Kingdom or a qualifying territory after the commencement of the Act will be a British citizen if, at the time of birth, one of their parents is either a British citizen or settled in the UK or a qualifying territory. The provision also includes special conditions for children born to members of the armed forces. Additionally, if a newborn is found abandoned in the UK or a qualifying territory, they are presumed to have been born there to a British citizen or a settled parent unless proven otherwise. Acquisition by descent. Section 2 addresses the acquisition of British citizenship by descent. A person born outside the United Kingdom will be a British citizen if their father or mother is a British citizen otherwise than by descent, or if they are serving in certain governmental services abroad. It also covers situations where a British citizen parent is employed under the government of the UK or a qualifying territory. Acquisition by registration. Under Section 3, minors born outside the UK or a qualifying territory may acquire British citizenship through registration, provided certain conditions are met. The application must be made while the individual is a minor, and the requirements include having a British citizen parent by descent, who fulfills specific residency and absence criteria. Special circumstances for registration. Section 4L allows individuals of full age to apply for registration as a British citizen under special circumstances. This may apply to those who would have acquired British citizenship but for historical legislative unfairness, actions of a public authority, or exceptional circumstances. Historical legislative unfairness may include situations where gender equality or marital status was not appropriately recognized in determining nationality. Public authorities refer to any governmental body, except courts or tribunals. Acquisition by naturalisation. Section 6 governs the process of naturalisation, allowing individuals of full age and capacity to apply for British citizenship. The Secretary of State may grant naturalisation if the applicant fulfills the criteria outlined in Schedule 1, which includes requirements related to residency, language proficiency, and knowledge of life in the UK. The British Nationality Act 1981 also includes provisions for the deprivation and loss of British citizenship under certain conditions, as well as the interpretation of key terms used in the Act. Additionally, it outlines requirements for naturalisation and citizenship ceremonies for successful applicants. An application for the registration of an adult or young person as a British Overseas Territories citizen under various sections of the law, such as Section 15, 3, 17, 1, 17, 2, etc., will not be granted unless the Secretary of State is satisfied that the individual is of good character. This requirement applies to registration under Section 17C as well, specifically where the relevant provisions fall under Section 15, 3, 17, 2, or 17, 5. The Secretary of State must be convinced that the adult or young person applying meets the standard of good character in all such cases. Furthermore, this requirement extends to applications for registration as a British citizen under Section 4K for those who are eligible for registration as a British Overseas Territories citizen under Section 17C, provided the relevant registration provision is from Section 15, 3, 17, 2, or 17, 5. Again, registration will not be granted unless the individual is deemed to have good character. Additionally, applications for registration as a British Overseas citizen under Section 27, 1, or as a British subject under Section 32 are similarly subject to the same requirement. The Secretary of State must be satisfied that the applicant is of good character before granting the application. For the purposes of this section, the term adult or young person refers to a person who has attained the age of 10 years at the time of the application. In the interpretation section of the Act, the term child's mother is defined as the woman who gives birth to the child. Similarly, the child's father is defined in various ways. It could be the husband or male civil partner of the mother at the time of birth, a person treated as the father under the Human Fertilization and Embryology Acts of 1990 and 2008, or a person meeting certain prescribed requirements of proof of paternity, as defined by the Secretary of State through regulations. Regulations governing these matters may also allow for the delegation of discretionary functions to the Secretary of State or other persons and may apply differently in different circumstances. Additionally, the regulations can be made through statutory instruments and are subject to annulment through parliamentary resolution. The expressions parent, child, and descended are to be interpreted according to the definitions in subsections 9 and 9A of the Act. When it comes to naturalisation as a British citizen under Section 6(1), there are specific requirements. The applicant must meet the requirements specified, demonstrate good character, have sufficient knowledge of the English, Welsh, or Scottish Gaelic languages, and show understanding of life in the United Kingdom. The applicant must also intend to make the UK their home or serve in Crown Service or an international organisation associated with the UK. The residence requirements include being present in the UK for 5 years prior to the application, not exceeding 450 days of absence during this period, and ensuring no restrictions or breaches of immigration laws during this time. If an applicant is serving outside the UK in Crown Service, they may meet an alternative requirement for naturalisation. In special circumstances, the Secretary of State has the discretion to relax certain requirements. This includes waiving residence requirements or disregarding restrictions if the applicant has indefinite leave to remain, is aged, or has physical or mental conditions that make fulfilling the usual requirements unreasonable. Naturalisation as a British citizen under Section 6(2) similarly has requirements regarding residence and absence from the United Kingdom, alongside the standard of good character, knowledge of language, and understanding of UK life. The individual must also not be subject to any restrictions under immigration laws during the application process.